This office mix deals with tort law, or cases where the wrongdoing of one party causes injury to another. So tort law basically deals with the compensation required in the case where somebody has suffered damages as a result of wrongdoing. That wrongdoing could be either intentional or unintentional. To prove tort, there are three key principles that have to be shown. And they have to be shown on the balance of probabilities, so not beyond a reasonable doubt. The first is that the defendant should have protected the plaintiff in some way. They owed them some duty of care. And that what the defendant did resulted in a breach of that duty of care. And that the consequence of that breach was that the plaintiff had some injury, whether financial or personal. And the main thing to note for tort law is that there is no need for any contractual relationship between the plaintiff and the defendant. So the concept of tort law started with the Donahue versus Stevenson case, where Mrs. Donahue went into a cafe with a friend of hers. The friend bought a bottle of ginger beer for Mrs. Donahue. She drank it and fell ill. There was a dead snail in the bottle, and so Mrs. Donahue sued the people who made the ginger beer, even though she clearly had no contractual relationship with that manufacturer, because she hadn't bought the ginger beer from the cafe owner, she certainly hadn't bought the ginger beer from the manufacturer. And this court case ultimately reached the highest court in the UK, the House of Lords, who held that the manufacturer did owe a duty of care to Mrs. Donahue, which was breached because they should have been able to realise that if they didn't protect the quality of their beer, it could cause harm to the customers. The Headley-Byrne case somewhat limits the extent of tort law in the case where a clear disclaimer is stated. So in the Headley-Byrne case, the company wanted to work with a customer, but the customer had made a very large order from Headley-Byrne, and they were going to have to spend some money to fulfill it. So before they went ahead with the contract, they requested some credit checks on that customer from the customer's bank, Heller. Heller replied in a way that stated they had no responsibility for their response, and they stated that the customer was considered good for business. The letter was sent with no consideration. So Heller proceeded on the basis of this letter with doing the work, but the customer went bankrupt and Headley lost £17,000 as a result of the bankruptcy. So Headley pursued the bank for negligence, stating that because the information was misleading, that was an issue. Heller claimed they had no liability because they owed no duty of care to Headley-Byrne. The court decided that had there not been a clear disclaimer that they provided the information without responsibility, they would have been responsible because even though there was no consideration, they were being relied upon for their special skill in being able to assess customer creditworthiness. But because of the clear disclaimer, there was no case to respond to. This was reinforced in the Wolverine Tube case. Noranda requested Arthur Little to do an environmental compliance of some of his properties. And Arthur Little created a compliance statement, clearly stating that it would do the work on a best effort basis and that the information should not be used outside Noranda's organisation. It turned out Noranda was actually going to use these environmental compliance statements from Arthur Little to sell its properties. It hadn't told Arthur Little that this was the intended use of the environmental reports, and under those circumstances, a best effort review would not have been sufficient. So Noranda provided the Arthur Little reports to Wolverine Tube, who wanted to buy the property from Noranda. And Noranda assured Wolverine Tube that they were not in breach of any statutes other than the few stated in the Arthur Little report, based on those reports. So after buying the properties from Noranda, Wolverine Tube discovered some significant environmental breaches, and so they pursued Noranda and Arthur Little in the courts. And whilst Wolverine Tube was successful at pursuing Noranda, the courts found that Arthur Little did not owe any duty of care to Wolverine Tube because the disclaimers in Arthur Little's statements were very, very clear. The documents should not have been used by any third party. The next tort case is very significant in terms of its consequences for any statements made by a professional engineer, even in passing. A contracting company was going to build a barn over a manure pit. The contractor had a friend who was an engineer who worked for the government, and contacted the engineer friend when designing the barn, discussed the plans for the barn design, and sent the plans through for a review. The engineer replied saying it was a good set of plans, they liked the level of detail, and they wished that they could spend that amount of time on each project. But the engineer had failed to note that there were actually some significant errors in the plan, and when the contractor finished the barn, it unfortunately fell down, parts of the walls failed. So the engineer was actually pursued in law for having incorrectly informed the contractor that the design was good. The engineer did not believe that they were being consulted by the contractor. They didn't have any contractual relationship. But the court found that the engineer did have a duty of care. They referred to the plans as good, and that meant that the contractor was able to believe that they had done enough. The contractor was relying on this special skill that the engineer had. So in order to avoid this type of issue, the engineer would have had to have added disclaimers to his advice. Clearly this has significant impacts to any comment made by a professional in their professional capacity. So we've seen that tort law does not require a contractual relationship between the parties. We've seen that disclaimers can limit liabilities in the case of tort law. And we've seen that if you have special skills, those can be deemed to be reliable, even if provided as mere advice, unless suitable disclaimers are added. The final case under tort law to consider is a case called Winnipeg Condos versus Bird Construction. So Bird built some condominiums, and they had a latent flaw in the design of the condominiums. The company that Bird built the condos for did not discover that flaw. That company subsequently sold the condos to the Winnipeg Condominium Corp. After buying the condos, at some point, some of the outside cladding on the condos fell from a 9th story. And Winnipeg Condos had to make some urgent, significant repairs to the outside of the building to avoid causing any harm to any passers-by or to the residents. So they sued Bird, even though they had no contractual relationship with them, to recover costs. And the court decided that Bird still had a duty of care to subsequent purchasers because of the fact that there was a latent defect that could have given rise to a real substantial danger to the inhabitants. Now, traditionally in contractual law, there's a concept of caveat emptor. Whoever enters into a contract needs to satisfy themselves of the terms. So you could consider that Winnipeg Condominium should have analysed the building they were buying to make sure that it was in a safe state. However, because of the latent defect leading to a real and substantial danger, caveat emptor was seen to be not appropriate in this case by the courts. And this decision was actually furthered in a Vargo versus Canmore case, where a similar latent defect was discovered before it actually had materialized, and the courts decided that it wasn't necessary to wait for the flaw to actually cause immediate danger in order to repair, as long as there was the potential for it to lead to a real and substantial danger, one could claim tort. So when considering a tort case, it's important to specify exactly what tort law deals with and provide the case history that I've just run through. Specify that there is no need for a contractual relationship, and identify the three principles of duty of care, a breach of that duty of care resulting in injury to the plaintiff. In analysing a tort case, it's then important to specify who each of the parties is, the plaintiff, the defendants, and whether these three key principles have been met. And as a result, the damages can be analysed and attributed to each of the defendants if they are small and one.